All right, Mr. Ogletree, we'll call that case first.
Thank you.
So we're on the record in docket 25-00786. That is People of the State of Michigan versus Keegan Chase Mowbray. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Ogletree.
Aaron Ogletree, about for Mr. Mowbray. Mr. Mowbray, can you state your full name? Can you state your full name, Mr. Mowbray?
And sir, you are Keegan Mowbray, is that correct? Thank you. This is the time set for a sentencing the matter. And Mrs. L, is there any restitution in this matter besides what's come out of the probation department? I don't have any additional restitution.
There's no additional restitution.
All right, thank you. Mr. Ogletree, have you had the opportunity to go through the pre-sentence with your client?
Yes, we did.
Any additions, deletions, or corrections?
No, not at this time.
Allocution, Mr. Ogletree.
Yes. I know last time we were before the court had mentioned about the concern about granting HIDA for the second time. We would ask if the court is still willing to grant HIDA. If not, we're in agreement for him to be sentenced under 769.4A. We would ask that he be sentenced there. We do have a disagreement in terms of not with the facts of the probation report, but in regards to their request that he submit to random PBT or urinalysis, and no bars or nightclubs. The current case has nothing to do with drinking or nightclubs. We would just ask that that not be necessary. And I do want to add, in regards to Mr. Mowbray, that I've come to know him, overrepresented him for the last couple of months, and I've seen a good amount of growth. I'm sure he'll be successful in probation, and one of the things is he's in line for promotion with Amazon. So if this was to be a public record, which if the court were to grant HIDA or the 769.4A, then he could continue to receive that promotion. So we're grateful for the opportunity that we hope that this court will present to Mr. Mowbray.
All right. Thank you. Thank you, Mr. Ogletree. Mrs. L, any question? I don't see, and I'm just reading the plea. I don't see that this was a drinking situation. I don't know. I don't see it. I see a soda pop was slapped from the hand. But other than that, I don't see this as a drinking, as alcohol or intoxicants were being used. But I may not. So from the people.
Thank you, Your Honor. That would be correct. I believe this incident was alcohol and drug free. So we don't think that is absolutely necessary for the probation period. Your Honor, our office is asking for the court to consider 769.4A status instead of HIDA status. At our last sentencing, we did hear the court talk about not being fully inclined to grant HIDA status, and our office has agreed with that for the second time. We believe that HIDA should be used once, especially with that other case. At this time, we would be asking for the 769.4A status.
All right, thank you. Mr. Mowbray, is there anything you'd like to say to the court before the court passes sentence?
I do feel as if I've very much grown in the time frame that this has all come about, and I do take responsibility for my actions, and appreciate you for giving me the chance to continue to grow my career.
All right, thank you. I don't believe probation is a one size fits all. Okay, and so you do present with a problem. The problem is this is your second offense. Okay, and we have to look at some of the underlying reasons for that. There doesn't seem to be anything alcohol related. So which is worrisome because that means that you've chosen the second time that we know of to hit somebody you reportedly care about. And we got to fix that. Okay, that's part of the court's responsibility, part of the district court responsibility, part of your responsibility. You must have better things to do with your time than be here on a Friday morning. So what we're trying to do is fix whatever the reason is we're here. I'm not worried about Mr. Ogletree in the next 10 months because you're on probation to me, right? I'm really worried about Mr. Ogletree, or Mr. Mowbray, I should say, in the next 4 or 5 years. You've got to make good decisions, okay? And domestic violence is a way of acting out anger management problems, things that you are involved in that aren't going your way, okay? And then you choose an act of violence for whatever reason, okay? So let's fix that. Let's fix that. So I am to fashion a judgment of sentence. This is for a guilty plea on May 20th, 2025 to domestic violence. I'm going to have you spend, and this is I believe there was a Killebrew. Was there any Killebrew agreement to YTA status? And they've indicated that 76940 will be acceptable. That's my understanding.
That is correct, Your Honor.
Mr. Ogletree, is that the understanding?
Yes.
Okay. I'm going to recommend that you spend 90 days in jail. Credits given for 1 day previously served. I'll suspend 90 days in jail. So no upfront jail. Okay. It's all. But I've ordered it, so you know. So this should be our last meeting, so to speak. Okay. Fines and costs. I'm going to set fines at $200. Costs at $200. For $400 fines and costs. Crime victims' rights fee of $75. State minimum cost fee of $50. And then I'll place you on probation for 10 months at $30 a month for $300. And you can pay all that at the end of your probation, okay? If you want to play it forward, great, but that'll be all due at the end of probation. And I'll give you a round number for that. I'll give you a total. So 300 plus 125 plus 400 is 825. A probation is sentenced for 10 months via Zoom. Your probation agent is, or at least who did the report, is Nathaniel Neves. Pretty easy guy to work with, all right? But you might want to go to the 5th floor and find out exactly what the Zoom number is, the ID, all that for reporting purposes. He's the person who would report you, okay? Your 76940 is granted. You'd have no contact with the victim, Carmen Hargrove, or to be within 2,000 feet, or where the victim lives, works, goes to school without this consent of the court. If Ms. Hargrove starts appealing to you, only the order of the court can trump another order of the court. And so go the other way, call law enforcement, whatever you need to do to protect yourself, okay? No assaultive or threatening behavior. I'm going to strike the no use of possession of alcohol, marijuana, or controlled substance. Submit to random PBTs, enter urinalysis, I'll strike. And no bars or nightclubs, I'll strike. I don't see this as an alcohol ingested situation. What I see this as is that for whatever reason, this kind of conflict has to be addressed in a different manner. It just has to be. Complete following rehabilitative services, pay fees, and provide proof of completion in the court. You are to complete the domestic abuse training. Nathaniel Neves can give you more on that, your probation officer. It's usually a week class, might be done online, but a weekend class. But check with Mr. Neves and then provide proof of completion. Not purchase or possess firearms, ammunitions, or weapons of any kind. Mr. Mowbray, do you have any questions of me concerning the judgment of sentence?
I do not.
Mrs. L.
No, Your Honor, thank you.
All right. Mr. Ogletree, do you have any questions of me?
No, Your Honor.
Oh,
Thank
all
you.
right. Thank you. I will sign the judgment of sentence accordingly. Make it pretty. Okay. All right. Anything else for the record in 2500786, Mrs. L?
Not for the people.
Mr. Ogletree.
Oh,
All right, Mr. Mowbray, I checked with probation. You should be all set, sir. Thank you for your appearance.
Thank you very much.
all right, take care.
You're all set, Mr. Ogletree. Thank you.
Bye-bye.
That is People of the State of Michigan versus Harlan Raby. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Schroeder.
And good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Raby,
Raby.
jeez Louise. Mr. Raby, who is standing to my left.
And sir, you are Harlan John Raby, is that correct?
Correct, Your Honor.
Thank you. This is the time set for a preliminary examination. Mrs. L, how we proceed?
Your Honor, at this time, the people are unable to proceed today. The officer that is necessary on this case is out of town for training, multiple hours away. I was made aware of this on July 28th. Unfortunately, I did not tell Ms. Schroeder until today, probably about 20 minutes ago, and that is on me. At this time, we are asking for a brief adjournment to have that officer here to testify. I believe Ms. Schroeder will be making a motion.
All right, Ms. Schroeder.
Your Honor, we would be asking the court not to grant the request for a brief adjournment or any adjournment on this matter. Mr. Raby is here. He is being held, I believe at this time, only on this file. And we are ready to move forward here today if we had, we would ask that a dismissal be granted. Thank you.
All right, thank you. I do have a fail to appear out of January 30th, 2025 with a 48-hour hold. And then we set it for probable cause and prelim on July 24th. Bond was then changed from 300 PR so to 100 cash surety, I believe. So bond is at 100 cash surety. And then we left on at the PCC. The indication is the witness has a conflict that was not previously indicated. Do we know the witness's schedule?
I do not, Your Honor. Unfortunately, I don't know the training schedules for them. Usually they are able to leave their training and come testify. I'm unsure why that was not the case for this one.
All right, here's my fear is we'd reset it and then he'd be in training again. So what I'm going to do is I'm going to honor the motion made by the defense attorney with the understanding that this could be reissued. Okay, this could be reissued. I'm going to dismiss without prejudice. And based on the review, you might end up in arraignment. The whole thing will start again. But understand you've been incarcerated the whole time.
Yeah.
So with that understanding, I will go ahead and grant the motion to dismiss without prejudice. And then I'll have that printed out at the request of the defense motion. And then, Ms. Raby, this may be reissued. So if it is, Ms. Zell will be in contact with Ms. Schroeder, but in the same time, it may be reissued. You should know that, okay, sir?
Yes, Your Honor.
All right. All right. I'm in possession of the Nolly process order of acquittal based on the defense motion for 25-00161. And I'm going to sign at the request. This is without prejudice. And then the public defender will be in touch with you if it's been reissued in order to turn yourself in for arraignment purposes. All right. All right. Anything else for the record in 25-00161, Mrs. L?
Not for the people.
Ms. Schroeder.
Could I get a copy of that dismissal? Your Honor?
Absolutely. And I don't see there's no contact but it would be a good idea to keep this with you just to let all the conditions of bond purge themselves from the system.
Yes.
All right.
That for your records, and if I could also get a copy of that for my records.
Absolutely.
Thank
We'll
you.
give you 2 copies each.
Perfect.
Thank you for your
Thank you.
appearance today.
Gosh, he had a couple of failures to appear.
And then who did we want brought up while Mr. Raby is?
I'll have to look at it here in a second.
Bring up Mr. Lewis.
Sure. So let's bring up Mr. Lewis after you're done fighting with the printer, which is better you than me. All right, and
It's not. Yeah, that's why I.
Lewis next.
I'm gonna go back to my office and like.
Yeah, we need, I mean, if it does get reissued for whatever reason, I would really. He's got. He's just. He's not the guy that's got there, selling stuff, so.
Oh, yeah.
His bond was set pretty low.
It was, he could not make it. I asked
Yeah,
him
he's-
point blank when I met with him at the jail. I was like, so it's only $100. It's like, he's like, I don't have anything.
Yeah, that's not a.
Isn't that why we switched it so he started earning time on that file?
Maybe, I think it had to have been because he got picked up for a failure to appear. And my guess is that's probably
I
why.
think he's been incarcerated ever since, so we're.
At least when he got picked up, he got picked
Did
up.
you see Catherine's email?
Yeah.
What you're writing back to him? Tell him no.
I
Tell him
don't-
you have to pay your
Because they were,
I'm basically
I
saying
don't
it, but a little nicer.
I have to look at
Oh,
it.
well,
Thank you.
You're welcome.
All right, I appreciate it. Cause like
Or I can handle it. I don't even care if he's
Kind of
here.
a
He's
sad
kind of getting in my
situation.
way, if you know what I mean.
Well, we have to bring him up because.
I know, he's here. He's downstairs.
Right. But Mr.
I was asking for like.
Sure.
Thank you.
24, do you have preferences to call these together? Or do you want to keep them separate?
I think we actually need to call them separate today. We are, the people are able to move forward on one file and not the other.
All
I
right,
guess
so,
could we start with the 159?
okay, 159. All right, so we're on the record in dockets 2500159. That is people of the state of Michigan versus Roy Melton Lewis. Will the appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Goodrich.
And Luke Goodrich from the Public Defender's Office, filling in for Stephen Milks today and representing Mr. Lewis, who's standing to my right.
And sir, you are Roy Melton Lewis, is that correct? Thank you. This is the time set for preliminary examination day on this file. Mrs. L, how we proceed?
Your Honor, at this time, the people's necessary witnesses have failed to appear. They were subpoenaed for today's date, but we have not had successful contact with them. We do expect a motion from the defense at this time.
Mr. Goodrich.
Thank you, Your Honor. Yes, it's this time the defense would move to have this matter dismissed.
Right, based on, so I can hear the printer going. Based on the motion made by the defense, the people are unable to proceed. The witnesses have been subpoenaed and failed to appear today. So we will grant the motion to dismiss without prejudice on 2500159. So in regard to this case, that means this case is dismissed without prejudice, which realistically means that people could reissue if they choose to. But for our cases, for our purposes today, the case is dismissed. There is a no contact order on this. So Mr. Lewis, we'll give you a copy to keep so you know the case has been dismissed. All right, anything else for the record in 2500159, Mrs. L?
Not for the people.
Mr. Goodrich?
No, Your Honor.
All right, so we'll make you a copy because it takes about 3 to 4 hours to purge this case, the 2500159 from the computer system. All right. And then we'll call to the record docket 2403240. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Lewis, Mr. Goodrich.
And Attorney Luke Goodrich from the Public Defender's Office, again filling in for Stephen Milks on this matter and representing Mr. Lewis, who's standing to my right.
And once again, sir, you are Roy Lewis.
Yes.
Thank you. This is the time set for a preliminary examination today. Mrs. L, how we proceed?
Your Honor, it's my understanding that today there's going to be a waiver of the preliminary exam with the understanding that this case will be screened for mental health court and 30th Circuit Court.
And is that a fair statement, Mr. Goodrich?
Yes, Your Honor, and when speaking with Mr. Lewis, I believe he would like to waive his exam today and pursue mental health court in the circuit court.
All right, may I inquire of Mr. Lewis of his waiver of the preliminary examination?
Yes, Your Honor.
All right, Mr. Lewis, you understand you have the right to a preliminary examination day. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Luke Goodrich. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it would be your wish today to waive your right to a preliminary examination, have this case continue in circuit court, will it be screened for mental health court? Is that your understanding, sir? And do you wish to waive your right to a preliminary examination? Do the people also waive their right to a preliminary examination?
We do, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I'll provide the bind over documentation for the party's signature. That's right. Thank you, Megan.
Mr. Lewis right here. This is the piece that he's dismissed with Mr. Schick. Then the case.
All right, thank you, Megan. All right, I'm in possession of the bind over documentation on 2403-240. I'm going to indicate that the examination has been waived on today's date, which is August 15th. Anything else to come to the court's attention before I sign the bind over documentation, Mrs. L?
Not for the people.
Mr. Goodrich.
Yes, Your Honor, we would like to address Mr. Lewis's bond at this time.
I have him. I have only on this case then, right? I have a 3,000 PR bond.
So, Your Honor, I believe Mr. Lewis has had several hearings with this court this year due to, I believe he was evaluated for competency and such. So he's had several hearings. He missed his last one. And then I believe there was a bench warrant and he's been remanded waiting for today. So I would ask the court to reinstate the bond at this time, considering he made all those other hearings. He's typically here very early. His nephew helps him out. He gave me his nephew's phone number to contact to let him know what's going on. So we would ask the court to reinstate his bond.
All right, Mrs. L.
Your Honor, the people have no objection to that request.
All right, I believe that any problem with getting Mr. Lewis here has been a kind of a forensics. Forensics has been involved in the situation. I don't have a problem resetting the bond in this. Now that that's all complete as I see it. But Mr. Lewis, I think Mr. Goodrich is covering for Mr. Milks. But when you talk to Mr. Milks or Mr. Goodrich, when they tell you to appear in court, and I think a nephew's involved.
Yes, his nephew helps him.
And if your nephew accompanies you to court, it's imperative that you be in court. Okay, I think that would keep you. I think that would keep you out of any future problems. All right, I will reset. So we'll set bond at the original bond set at 3,000 PR. Anything else for the record, Mr. Goodrich?
No, Your Honor.
All right, I'm going to sign the bind over documentation. And Mr. Lewis, your time in district court is done. You're off to the circuit court where you get your next appearance from Mr. Milks, most likely. All right, sir?
Okay.
Okay. Anything else for the record in 2403-240, Mrs. L?
Not the people.
Mr. Goodrich?
No, Your Honor.
All right, Mr. Lewis, good luck to you. Thank you.
Take care. This with you, okay?
Debbie, who we need next?
What a great question. Want to do Delmarter?
Yeah.
Delmarter? All right.
All right.
And in the meantime, Your Honor, it does look like we are ready on Darnell Wheat.
All right. That is.
Let me know.
And then, Your Honor, if you could approach by about Delmarter just briefly.
Sure. Do you want to go on chambers or do you want to go on the record? Where? 25-01656. That is people of the state of Michigan versus Darnell Wheaton. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Abbott.
Good morning, Your Honor. Attorney John Abbott with the Public Defender's Office, representing Mr. Wheaton this morning. It's Melanie Wanji's case.
All right. And sir, you are Darnell Wheaton, is that correct? Thank you. This is the time set for a probable cause. I have it as a probable cause conference. Mrs. Zell, how are we proceeding?
Your Honor, it's my understanding that today there will be a waiver of the preliminary exam with a plea offer to be placed on the record to be preserved until the first pretrial in circuit court. And I am pulling that up right now. That offer is to plead to a count of possession of a controlled substance under MCL 333.74032A5, which is a 4-year felony. And then a count of CCW under MCL, apologize, I don't have that one pulled up. MCL 750.227.
Is that your understanding, Mr. Abbott?
That's most of it, Your Honor. The other half would be that they would dismiss the balance of the charges.
In circuit court, is that correct?
That is correct, Your
All
Honor.
right. Is that your understanding, Mr. Abbott?
Yes.
Okay, thank you. May I inquire of Mr. Whedon of his waiver of the preliminary examination?
Yes. Thank you.
All right, Mr. Whedon, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed in the identity of the person who committed that crime. You are represented today by Attorney John Abbott, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding that it would be your wish today to waive your right to a preliminary examination. An offer has been placed on the record in regards to this file, and to preserve that offer, you would waive your right to preliminary examination, have this case continue to circuit court where the offer would be open to the first circuit court pretrial. Is that correct? This is all, it's open until the first circuit court pretrial. Okay, thank you. Is it your wish today, Mr. Whedon, to waive your right to a preliminary examination? Is that a yes? Okay, thank you. And Mrs. Elder, the people also waive their right to a preliminary examination.
We do, Your Honor.
All right. I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I'll provide the bind over documentation for signature. I'm going to draft you, Mr. Abbott. Thank you. That'll probably need the prosecutor's signature. At least the new ones do. The old ones didn't need that.
You can tell where I can.
Yeah,
You should see the new plea agreement sheets. They
I
have.
just saw it. I just saw it. You would think none of this was ever placed on the record.
Right.
All right, so I'm in possession of the bind over documentation signed by all the parties on 25-01656. I'm going to indicate that this examination has been waived on today's date. Anything else to come to the court's attention before I sign the bind over documentation, Mrs. L?
Not for the people.
Mr. Abbott.
Nothing from the defense. Thank you.
All right, I'm going to sign the bind over documentation. Mr. Whedon, your time in district court is done. You're off to circuit court, where you'll most likely get your next appearance from Ms. Wanji. Is that correct?
Yes, Your Honor.
All right. All right, so you're off to circuit court. That'll be over at the Grady Porter Building. Anything else for the record in 25-01-656, Mrs. L?
Not for the people.
Mr. Abbott,
No, thank you.
you should be all set, Mr. Wheat. Thank you for your appearance. Tell them.
This was a party court system. What you said.
All right, Mr. Etheridge, have you had sufficient time to talk to Mr. Delamarter?
Yes, Your Honor.
All right. All right, so we're on the record in docket 25-01-608. That is people of the state of Michigan versus Mark Delamarter. Well, appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Etheridge.
Morning, Your Honor. Attorney Derek Pitts, Public Defender on behalf of Mr. Delamarter, who is in the court standing to my right.
And sir, you are Mark Delamarter, is that
Yes.
correct? Thank you. This is the time set for a preliminary examination today. Mrs. L, how we proceed?
Your Honor, at this time, both parties are coming with a request for an adjournment for some additional investigation to take place in this case. Additionally, there seems to be another felony file that's making its way through the system.
That, and yeah, that was, that is in 54A.
We believe so.
But we're not.
I think my system is incorrect based on the APA who charged it.
Okay.
I think it's showing up as the wrong court, but I do believe it's 54.
All right, and we checked our computer system. I do think it's out there under 54A, but that's yet to be determined. And then there's another ordinance case, and we're gonna set that on for the ordinance docket on August 25th at 10 o'clock. So that would be the trespass ticket that's out there. Mr. Etheridge, is that a fair statement? Mr. Delamarter is going along with the request for adjournment for investigative purposes.
Yes, Your Honor.
All right, we will reschedule. I think there's a prior failures to appear, so we don't have to grant good cause or just cause for an adjournment, and we'll reschedule for.
Far out do they need?
How far out?
If we could do at least 3 weeks, that'd be great.
At least 3 weeks. You're, I think that's right in our wheelhouse. Yes.
September 12th at 9.
September 12th at 9 o'clock. All right, we'll see what happens with the other cases in regards to where they end up, but we've reset this prelim for September 12th at 9 o'clock. Anything else for the record in docket 25-01-608, Mrs. L?
Not for the people.
Mr. Etheridge.
No, Your Honor. Thank you.
All right, Mr. Delamarter, we'll see you on that date. Thank you for your appearance today. Thank you.
All right. I get the updates for right now. Mark. I get the updates, I'll let you know.
Yeah.
Mrs. L, did you have anybody you want Megan to bring up while we?
Great question. Probably.
I get that other information.
Do you want Trinidad?
Yeah, might as well bring him up
All right.
now.
Trinidad? Reed?
So Ms. Slaviak,
Yes, Judge.
when you take down Mr. Delamarter, you can bring back Trinidad Reed. Those are both. All right, did you want to call Shakur?
Yes.
All right, so we're on the record in docket 25-02276. That is people of the state of Michigan versus Muhammad Shakur. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. L.
Good morning, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of the defendant, Muhammad Shakur, who is sitting to my right.
And sir, you are correct by pronunciation, Muhammad Shakur.
Managed report, yes. Sir.
Thank you.
Thank you.
Thank you. This is the time set for a preliminary examination today. Mrs. L, how we proceed?
Your Honor, it's my understanding that we will be having a waiver of the preliminary exam. There is an offer to place on the record to be preserved for circuit court. That offer would be to plea as charged with an agreement to hide a status and with dismissal of the retail fraud second file that is in front of this court. And I will pull that file number up. In just a moment.
25-01937.
That is correct.
25-025 say it again.
01937. SM.
That'll be dismissed in circuit court. Or did you want it dismissed?
Upon he has to take the plea.
Yeah.
He has
Successful
to,
plea
yeah.
and sentence.
Yeah.
All right. All right, and is that your understanding, Ms. Donnelly, concerning the offer that's been extended on the record?
Yes,
All right. May I inquire of Mr. Shakur of his waiver of the preliminary examination?
yes, sir.
All right, Mr. Shakur, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented by attorney Sarah Donnelly today, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it is your wish, it would be your wish today to waive your right to a preliminary examination. The offer has been extended and placed on the record. I'm assuming it's open till the First Circuit Court pretrial.
That is correct, Your Honor.
And it's open till the First Circuit Court pretrial. In order to preserve that offer, is it your wish today to waive your right to a preliminary examination?
Yes, Your Honor. It is.
And Mrs. L, do the people also waive their right to a preliminary examination?
We do, Your Honor.
All right. I find that the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And Ms. Donnelly, I'm going to draft you for the bind over documentation to be signed by all the parties. Thank you, Ms. Donnelly. Thank you, Ms. Donnelly.
Thank you.
All right, I'm going to indicate I'm in possession of the bind over documentation on 25-02276. I'm going to indicate the examination has been waived on today's date, which is August 15, 2025. Is there anything else to come to the court's attention before I sign the bind over documentation? Mrs. L.
Not for the people.
Ms. Donnelly.
Not for defense.
Right, I will sign the bind over documentation. All right, Mr. Shakur, your time in district court is done. You're off to circuit court. Will you get your next date of appearance from your attorney, Ms. Donnelly? All right, sir?
Okay, thank
All
you, Your
right,
Honor.
thank you. You're all set.
You have a good day.
You too.
Earlier, okay. Yeah.
Mr. Abbott, did you have any questions?
I do, Your Honor. Is it possible to raise the issue of bond conditions on Mr. Wheaton's case even though after you sign that?
I don't think I can. I think I mean, I can, if you don't, if there's no objection, I think we can reopen and look at bond conditions. But without objection, but Mrs. L would have to. Yeah,
Mr. Army.
all right. I think on Mr. Abbott's case, which is
Mr. Wheaton.
Mr. Wheaton, they want to reopen just to address bond conditions.
Oh, yeah, that's fine.
Maybe.
But
I don't know where the file is. She may have taken it.
we may need Ms. Slaviak to come back.
What's the name?
Wheaton, you see it over there?
No.
Yeah, she probably dropped it off on her way. Hang on.
If we can find the file, we'll address those bond conditions.
Thank you, Your Honor.
And then she's bringing up Reed, right?
Yes.
All right, just come get me when you're ready.
Okay, I'm ready.
Oh, this is Mr. Wheaton.
Oh, pretty sure.
We got everybody.
Ready for a lot now.
All right, so Mr. Abbott, let's go on the record on that file. And then we'll go on Mr. Reed, and that'll give Ms. Donnelly a little chance to talk to Mr. Reed. So we're on the record, back on the record in 25-01656. That is people of the state of Michigan versus Darnell Wheaton. Mrs. L, do you have any objection to reopening after I've signed the waiver, but reopening just to address a modification of bond?
I have no objection, Your Honor.
All right, so we will address the modification of bond. Mr. Abbott.
Thank you, Your Honor. It's my understanding that Mr. Wheaton's bond requires that he stay away from children.
Let's see, I have under the age of 18.
And he, part of his income is derived as a substitute teacher, Your Honor. I asked the court to consider modifying that so he can continue to substitute teach while the case is pending. The firearm has been confiscated by the police. There's still a presumption of innocence. There's no allegation in here that he had anything to do with any children at all. He's basically fled the scene of a traffic accident, allegedly, which is part of the municipal court case. And things went downhill from there. But there's no allegation in the charges or in the facts of the police report that have anything to do with children. So we'd ask the court to modify that aspect of the bond so he can continue his employment.
Mrs. L. What, do you know anything about? I was looking at the probable cause affidavit. And I didn't, the only thing I saw was that would require was that he was a teacher at Atwood from grades 6 to 8, and he removed the plate. I don't see any.
Yes, Your Honor. I believe that bond condition was asked for by our office and requested by our office specifically for the reason that it appeared that he was traveling towards or from the elementary school at the time that these the firearm and the drugs were in the car. I believe that is why that bond condition is in there.
Okay.
I would say that it probably, we wouldn't be fully feeling great about a continuation of a substitute teaching position. However, if the court is inclined to remove that bond condition, we would believe the schools would be able to make that decision for themselves.
Well, I mean, the bond conditions would include no out-of-state travel, I'm gonna add, there was not a part of this, but I'll add no assaultive behavior. No use of alcohol or drugs without a prescription. But then I would strike the no contact with underage students unless they find that, unless there's some other reason that the school finds he shouldn't be a part of the substitute teacher requirement. I think that would cover for our purposes what was necessary. Because the school could always hire their substitute teachers or not hire depending on. So I will modify bond to indicate no assaultive behavior. No use of alcohol or drugs without a prescription. And then I will take away the no contact with minors under 18. Is modified. So I'm striking that no contact with minors requirement. But I've added no assaultive behavior or possession of narcotics or alcohol without a prescription. And that should allow him to substitute teach if need be in order to augment his income. Anything else for the record in 25-01656, Mrs. L?
Not for the people.
Mr. Abbott.
No, thank you, Your Honor.
All right,
Thank
Mr.
you for
Wheaton.
allowing me.
All right, Mr. Wheaton, you're all set. Thank you for your appearance today.
John, wait 1 second. I got his new. Here.
So are we ready on Reed?
So he, I say he agrees that he wants to.
We're adjourning that one. I have one officer here for the CCW.
Okay. So we'll get the solicitor to both cases for the same date. Okay.
All right, and did you want to call, we'll call them separately since you're substituting for Kaplan on the second case, is that correct? Or doesn't matter?
Doesn't matter, Your Honor, all at the same time. Oh, yes, of course. Yes, I am still the attorney. No,
You're not.
well, they never got me substitution. Oh, it's pro per right now. Oh, I see. Interesting.
All right, so Mrs. L, how did you want to call the cases?
We can go ahead and call them together.
All right. All right, Mr. Reed, you can come up here. So we're on the record in docket 25-02275 and 25-02284. That is People of the State of Michigan versus Trinidad Reed. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Donnelly.
Sorry, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of the defendant Trinidad Reed for both cases, including the one where it's attorney of record Jeff Kaplan. I'm
Okay.
covering for him today. Thank you.
Thank you. And sir, you are Trinidad Reed, is that correct?
Yes, Your Honor.
Thank you. This is time set for a preliminary examination on both files. Mrs. L, how we proceeding?
Your Honor, it's my understanding that there's being a request for a little bit more time on one of the files, and on the other file, we did have only one officer ready to proceed. So we are asking for an adjournment on both files today. I do believe both parties are in agreement on that adjournment, but I will defer to Ms. Donnelly on that.
All right, Ms. Donnelly, the request is an adjournment on both files. And is this going to be a request, a good cause request, or a waiver of the 21-day rule?
It'll be a good cause your request, Your Honor. It's my understanding that his Mr. Kaplan, the other attorney on the file, he personally needs more time to prepare for the preliminary exam.
Right, so we'll adjourn the preliminary examination for a good cause, with the understanding that there may be some investigative issues and discovery issues. Both sides are requesting an adjournment, but we'll get the soonest available date, which may be are you looking for 2 to 3 weeks?
I would say, yeah.
August 28th
August 28th.
at 9.
So we'll grant the good cause adjournment for August 28th at 9 o'clock on both of these files. And they'll both be set for August 28th at 9 o'clock. Anything else for the record in 25-02275 or 25-02284, Mrs. L?
Not for the people.
Ms. Donnelly? Anything else? Ms.
No,
Donnelly?
we're good, Your Honor.
All
Thank
right.
you.
All right, Mr. Reed, we'll see you on August 28th at 9 o'clock.
All right, thank you.
Thank you. Ms. Schroeder, is Mr. Austin incarcerated?
Yes, sir.
So we could probably bring, well, the two last ones are incarcerated.
We are ready to go on Mr. Austin based on
All right.
PSI.
So Megan, when you're ready, you can bring up Mr. Austin when you take Mr. Reed down.
I gotta fix that.
I think you changed. I think that's correct.
Yeah, that's right. So I reprinted it. Yes, I count.
Okay. Yeah, I think we updated, like,
Yeah.
Obviously, you apologize. Yeah,
because I think he's a time server.
Yeah, because I had to use the calculator. No, because
He just needed a good.
like chunks, you know what I mean?
Yeah.
Can I give it a second?
Whatever. You going back to the office or you didn't?
Yeah, I got probably homes. 12 and 4:30. I got time.
Yeah. I'm gonna try to go, well, my mom's gonna go late this morning.
So I'm gonna tighten up her. Get the hell out of here. Yeah, but get the hell out of the staff meeting.
That's what I'm, oh, we have a staff meeting?
Yeah. But don't worry, but here's the thing, is you can't be there.
Oh, I missed staff meetings for you. Here.
I couldn't help it. I'm trying about it. I'm trying, but I don't, I was muttering some things under my breath, like her sister next to me. Like, saying the things everyone's thinking. And then because I'm like, I literally just sat down and I know exactly the conversation's going on.
I mean, do you want me to print the email?
And I'm gonna volunteer.
Oh, yeah, that'd be good for the file.
Ms. Riddle just said that she doesn't sell theirs. I got
Yeah.
You can go handle that.
Gordon will put
That's
something, there's a question,
You are volunteering.
because I think,
Thank you for the
I
comment.
think bond has been set.
No, just take it. Just go. Just take it. And then he was bumping and moaning and whatever yesterday about having to go handle stuff. Sorry. I was there when you said, oh, I'll handle it. You better have to look at it. And,
All right, Mrs. L, come get me
and
when,
he was like, oh, I can do that. I know that guy. And
Right
he's like,
away could
really?
be-
He's like, yeah.
and then we'll just bring
And
up
so he's like,
fumes
well,
after.
thank you, sir.
Sounds good.
And he puts it on
Awesome.
the, yeah. Looks like. And then he's sitting there next to me talking. And I went, dude, you volunteered. He already had someone lined up to cover it. You said, hey, I'll do that. And she was like, shut up. You shut up.
One of his great things.
A murder complex.
Or no, they don't get them
Sir, my mom does the same damn thing. And it's annoying with her and it's real annoying. Yeah, because you, I don't mean, you're not family. My mom, I love, I don't like her, but I do love her. So I tolerate her a lot. I don't have to do that. And then he was like, what is it? I'll learn to keep my mouth shut. I'm just like, I made that comment. That was one of the moments that there was a snickering and then. It's not, he makes it so hard and all the things are low hanging fruit. He's a tree of low hanging fruit. And I don't know about you, but like I said, I grew up in a family where if you left that low hanging fruit, if you left that door open, you were gonna get shot. I couldn't, I'll hit myself. Exactly, like, I mean, that was the family I grew up in. My mom's side of the family, like they would, with him, they would have.
Never got to experience it. You're too young.
Don't bend over and no loading.
And my mom, I remember there was a time back when I was, I brought my mom's car. And I was going with my grandmother's house, her mom's house. He lived 2 miles from us. And then right around the block was my mom's youngest brother. He was over. And I knew they were watching. I just got my trying to park the curb with the car. And I ended up down the road. And I'm like,
My dad got whacked.
he said, and I was like, really? Like, everybody was just looking out the window like, almost, you almost got it.
Oh, yeah.
Yeah, I am aware. Can we not?
Yeah.
You're just
It
like,
was like this.
as long as you're aware.
So no, you just make yourself, you just make yourself a target.
All the time.
And
And it's just like,
there's a point when it's like that. When right when he got laid off.
we could cut back on 90%.
I don't think, you know, it's just ingrained in him. You just constantly see, he's such a negative Nelly, he's such a.
But anymore,
That's a
But
power.
I'd be like, yeah,
it's
he
like,
had a
sir,
case. It's got all this junk.
I swear to God, one day I
He's got a
was
whole
trying to-
spectrum.
You got Blackberry.
And then
Ocean, he's
Tuesday,
trying
I
to
was-
see, like,
I was already-
Blackberry, and it's like-
I was already ready to cry and
Right.
yeah, going, and I'm, no,
And
not
I'm like,
Tuesday, looking
yeah,
in on
why
Tuesday.
is he so-
But Monday,
you know, so they're more secure. They're more
and
secure.
it's just not.
And I'm like, do you think
No, it's just never,
he's gonna
just
try to hack
sit
this
inside.
through Blackberry?
ever.
Not exactly trying to hack this through sell software.
Absolutely what's going on, and I'm like, I'm going to.
Not telling the government,
Straight
selling
up.
software. like
Go down there and
businesses.
slow down 5 seconds, and I'm already. Do with me. You're the cake, I'm facing the cake, and you're about to become my whipping boy.
Are you going back?
I will, but I gotta do a sentence and I just freaking forgot.
Well, I forgot, you know, that I gotta send it to you earlier this week. I didn't only forgot about it, wasn't on my schedule. And I.
It should have been on my schedule in fairness because Wendy earlier this week did email stating that they got
Oh.
the PSI done earlier than expected. They were just going to move it up to Friday, so Monday. I have her email. Yeah, okay, so. Yeah, and I'm like, no, and I'm like, it was there. I just didn't realize she changed. I didn't, it didn't stick out. We should change the date. So I didn't update my schedule.
I gotta go talk to Tree Tori. Apparently we were set for sentencing.
Whoops.
But you know, it's actually for the best because I hear Bacon were giving a copy. It's updated copy. So now when I talked to him today, you should.
And you
have-
didn't get any email or call?
I did get an email, but the problem is it didn't go to the office too. Yes, I finally found, I was like, wait, did I get an email for that? And yeah, I found it, but it was only sent to me and Bacon, or not to the office to make sure.
At least usually when that kind of shit happens, at least I think it's like, what's his name, Dale?
Yeah.
Dale will be like, you'll follow up. You'll be like, hey, where are you?
Yeah.
Things like that. I'm like, thanks, Brian.
Yeah,
that's
are
what
you
happened.
telling them we're ready or do you want me to?
Gotcha.
I'm just gonna make you do everything today.
Thank
Feels
you.
like the best
Hey
way to do
there,
it.
Tony. How you doing? So we're here today for sentencing. We got a report here. It's long, but whatever. But then at the end of the day, what it is they're saying time served, because you've already got like 79 days in. And it's on 93 days, so do you have any reason to want to? I figured you might. I figured you might. I figured you might. I didn't think there'd be any reason for you wanting anything more than that or anything different than that, but yeah, so I'm not, that's. She goes through. You better, you keep finding it. You keep finding it. All right.
You seated.
Get you on your way. You got no other holds, right? I know that's. Okay. Yeah, for this case, yeah. Yeah.
All right, so we're on the record in docket 24032. That is people of the state of Michigan versus Tony Austin. Appearances for the record, Mrs.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Schroeder.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Austin, who is present, stands to my right.
And sir, you are Tony Antoine Austin.
Yes, sir.
Thank you. This is time set for a sentencing in the matter. Mrs. L, is there any, I have restitution at $885.
That is what I have as well, Your Honor.
And is there a pink sheet in the file in regards to Tucker Briggs?
I do not believe there is. If you would like, I can complete one.
Okay. That was my only indication, is that I didn't know restitution, we had a full restitution. Is that your understanding, Ms. Schroeder?
I believe I do understand there is going to be a restitution request on this. I just think he's going to need some time to pay it. That can be done through collection.
Right, yeah, that'll probably go through, depending on the judgment of sentence, but, all right. Have you had the opportunity to go through the pre-sentence report with your client?
I have, Your Honor. Yeah.
Any additions, deletions, or corrections?
No, Your Honor. And I can move to elocution if the court is ready.
I'm ready, thank you.
Thank you. I would just ask the court to adopt the recommendation for the time served. Mr. Austin during this time period has been in since looks like July 10th. Obviously, unfortunately, there had been prior failures to appear on this file, which was what resulted in that. However, and gosh, I think he's got even more time than the 79 days, and it looks like there may have been, our numbers might be off. Regardless, he's either at or above the amount that he would have had to serve on the disorderly person. So I'd ask the court to just time served and let him go on his way and get him set up with a payment plan and eventually for the restitution. Thank you.
Thank you, Ms. Schroeder. Mrs. L, is there anything you'd like to say to the court before the court passes sentence concerning file 24032? 03260.
Your Honor, actually, just regarding restitution, I'm finding just an inconsistency in the probation report and the victim impact statement that our office received. Our office received a request for $685, not $885. I'm unable to find a receipt or anything of that sort to confirm the amount.
Maybe if I may propose a solution,
You may.
my thought would be, I mean, I don't know how this is gonna work, but maybe leave restitution open for 30 days until we can get actual confirmation. I don't know how that would work, but just an idea.
I hate to keep the file open.
Certainly.
$885 is what probation indicated, but the indication is not that from the victim.
That's my understanding, Your Honor. I'm pulling up our case file or evidence file right now to see if there was a receipt or something to support the amount. Otherwise, I do believe at this time we would be asking for the 685 based on that being what the victim requested.
See if there's anything that.
Can you indicate what the 665 is for?
Is it for the,
I can show you the impact statement.
Okay.
So he doesn't write literally anything, but then just down here, cost of damage property. 685. No receipts.
for the scooter?
Yeah. And then I didn't have an amount in the police report that I saw.
I don't see it either. I mean, it was returned. I guess. So
The other option, Your Honor, is to, and this is, this is never my favorite option, but we could set this for a restitution hearing and have Mr. Briggs come in and actually produce the evidence of the amount if that's preferred.
Okay, I have a note from Jody Briggs. That's based on,
So in our last conversation, and I apologize for interrupting, Your Honor.
Yeah.
It looks like it was the tow fee that we're asking restitution for. The tow fee was $850. So that would be what we would be asking for.
I have that. And this is from where probation gets of a stolen moped. And the estimate of the stolen moped came from the victim who said $800 plus the $85 towing fee. That was that's where they got the number.
Okay.
So Ms. Schroeder, I think the $85 towing fee sounds reasonable.
yes.
The $800 moped, we can have a hearing just to see if any documentation concerning that, just for restitution purposes.
May I
Because
speak?
that's more,
That's a little more squishy.
Yeah,
let's
that's-
say, for lack of a
that's more
technical term.
subjective.
If I may speak with Mr.
You
Austin
may.
here. It is up to you if you want to come back. Open or not, that is up to you. It would require another hearing for you and you to come. Yes. You want to have one come back for a restitution? Yes. Or no? You don't? Well, then you'd have to agree then to pay the $850. You sure? I'm gonna ask you some questions here in the back. All right. Thank you, Your Honor.
All right, how would you like to proceed, Ms. Schroeder?
If I may, voir dire,
You
Mr.
may.
Austin, thank you. Mr. Austin, You and I have spoken just now, correct?
Yes, ma'am.
And you've also been listening to the discussion on the record that we've been having with the court and the prosecutor, correct? And that is to make sure you keep your voice up for the record.
Yes.
All right, so, and this has to do with restitution amount, correct?
Yes, ma'am.
And we have discussed that the $85 tow fee that was indicated by the court and as well as the prosecutor, while we do not have documentation necessarily of that, would be a reasonable and quite frankly, I think, standard, and it would be entitled, correct?
Yes, ma'am.
The owner for that tow fee, because I do believe the police report indicated the vehicle did have to be towed. And then with regard to the additional outstanding $800, for that, as the court has indicated, and as I have indicated, you would, because we do not have documentation regarding where that number came from, you are entitled to have a restitution hearing as to that. Do you understand that?
Yes, ma'am.
And you understand that because it appears to me you probably have served the maximum possible penalty on this, you very likely, I will not speak for the court, but very likely you would not be held in custody if you wanted to have that restitution hearing. Do you understand that?
Yes, ma'am.
And it is your choice today that even though you know you have not seen documentation regarding the $800, and even though you understand that this is not going to be something that would, in my understanding, would not keep you in custody longer, you're asking to waive your right to that restitution hearing and just what they call agree to or stipulate to the amount. Is that correct?
Yes, ma'am.
And that is, you're doing that after having a chance to ask me questions, correct?
Yes, ma'am.
And you're doing that even though you have not seen receipts on any of this or documentation or testimony, correct?
Yes, ma'am.
And you understand you are entitled to those things. You understand that?
Yes, ma'am.
All right, Your Honor, I believe.
All right. All right, so no objection to restitution to be ordered in $885 based on Mr. Austin's review of the material and then comments and questions made by Ms. Schroeder. Mr. Austin, is there anything you'd like to say to the court before the court passes sentence? Okay. Mrs. L.
No, Your Honor, at this time, we'd ask that the recommendation be followed.
All
We
right.
do have a pink sheet for the court.
All right, so I am going to order, this is for a guilty plea that occurred on April 25th of 2025. I'll make sure that and I'm ordering that on count 1, this is for no contest plea, disorderly jostling. Count 2, no contest plea, receiving and concealing less than $200. It is ordered the defendant spend 79 days in jail. Credits are given for 79 days previously served. I'm going to waive fines and costs on disorderly jostling. We'll waive the crime victim's rights fee and the state minimum court cost fee. We'll keep the restitution order of $885. So that'll be a total of $885. And then on the receiving and concealing, we'll set fines and costs at $100, costs at $100, crime victims' rights fee of $75, state minimum court cost fee at $50, for a grand total of $325. And that give you a total of, that's $885 plus $325. $1,210, and that'll be all referred to collections. Collections. We'll make it. We definitely need to make this one pretty. The full sentence is the refer to collections of $1,210. So once you're out, you can go to the City of Lansing Collection Department, 6th floor, just go to the counter and they'll set you up with Marquita, and then she'll have that file. And then the rest is time served. All right, sir. Anything else for the record in docket 2403260 Mrs. L,
Not for the people.
Ms. Schroeder.
Now for the defense, thank you.
Okay, you should be all set, Mr. Austin. Thank you for your prayers.
Take care.
We need to bring June up.
So I think that we can have it as Jeff.
Judge, do we need to bring Humes up?
Yes.
Yeah, let's bring Humes up just because we're adjourning it again.
Should get some paperwork, I think.
No, he doesn't.
He doesn't? Okay, just remember to come back here once you're out of custody. You come back to the 6th floor of this building, you get yourself set up with your payments, okay? All right, take care.
What's not saying?
Oh, that's,
You're all set.
okay.
You're all set.
It's all right. We got it taken care of.
And my understanding is the plan is to just adjourn Mr. Humes for conflict counsel. And that, is that right?
I think so, yeah. Because he still doesn't have.
We'll make a record and. So you're gonna make that one look all pretty.
I didn't hear one of the numbers and I knew that. I wanted to interrupt you, you were on a roll.
Got my.
Judge, I was still taking the day out of Christmas off that Friday. Is that correct? You canceled the rest of the week off.
Keep it, yeah.
And then you took the following week off.
No, Christmas is a long ways away.
I know, but I had it black and the rest would be questions. And he is trying to do that calendar. I didn't, I'm watching it correctly and I'm telling her I did it correctly. Because we were still taking the 26th off. That's what I have.
Yeah, I know,
Because that's the Friday, Christmas is on Thursday, the 26th is a Friday, and then you have the whole next week off. It really wouldn't make any sense for you to come back for Monday.
yeah, but I can't.
Oh, oh, that's, no, I have.
So I would assume if that's how you had it locked up, that
Okay.
that's what we were requesting.
That's my.
It sounds. It sounds like I would take the day after Christmas just because
It makes sense.
it makes sense.
I don't think there's anything I'm forgetting.
You should be all set, Ms. Schroeder.
I did not.
I think we have Mr. Austin and Ms. Delvero this afternoon.
Even though I had Ms. Holden did send me the email with everything that they were moving up Mr. Austin's sentencing, I completely forgot to adjust it in my schedule. And the only reason I even caught it is I was like, even though people had mentioned it this morning. And I was looking at the schedules out here just to be sure, like, I think I'm missing something. And so I'm looking, I'm like, oh, that's what I'm turn around, come back.
But we had, it really, everybody's incarcerated except for 2, so.
Yeah. I just was like, man, I had a little bit of everything everywhere.
You did.
And I was just like, I gotta make sure I'm not forgetting something. And it turned out I was, so.
That was a pretty straightforward sentence.
Oh, yeah.
Well, if you turn your phone off, then you hear about.
I hope he does all right. We'll see.
Yeah, he's got a lot on his plate.
He does, and he's not, he's a pest, he's not
Are you playing?
a.
He's
I'm not a criminal.
older than he looks.
Hmm?
He's older than he looks.
Yes.
Because he looks pretty young.
Yep.
But
Looks like
he's-
like in his 20s or 30s.
Yeah, late 20s.
Yeah, he's not.
With my dad or Jess.
He's almost, he may be 30.
Yeah.
He may have just turned 30.
Yeah.
Well, you have to.
Yeah.
Yeah,
So-
I hope he can get it turned.
Me
around.
too.
I'm sorry, I'm trying to.
He's not a bad, from my interactions with him, he's not a bad guy. He
That's
just,
just, making bad decisions.
Oh, yeah.
Exactly. I don't.
I've never
Oh,
been-
yeah.
not a criminal mastermind by any stretch.
3 or 4.
Watch them. I'm so hot. That's why I'm not that good. What's that?
I guess we'll see the results of the tournament this weekend. Exactly. And then
Yeah.
we can reevaluate.
Yeah, the haters will be so mad when I go come in last. I should put up that 97 tomorrow. Yeah, there's like Ross came.
Where are your meetings?
What's that?
Where are your meetings?
The doubters, the naysayers,
I can just identify as one of Ross's haters.
but. You know that. Kind of deep.
All right, everyone. Have a good rest
You
of your
too,
day.
take
and
care.
weekend. All.
Bye.
Ouchies,
Wow.
push, not pull.
We do that every
Cut
time.
City Hills. Well, you're gonna be outraged.
No, I'm. So
We didn't writ.
What do you mean, Ross?
what if you just have like a
He's in our-
crazy
He's in the.
good lucky day?
Be downstairs. So
Yeah.
yeah.
We didn't writ.
He's done.
He's not here.
No, I've got him as here, but we didn't writ him.
He should be Lazarus County, I'll check.
He is.
She's crazy.
She said there's other things to do in call. I'm like.
He's right here.
Ah,
All right, Mr. Humes, you can come up here,
Right.
right
He
there.
just means right there.
All right, so we're on the record in docket 25-02289. That is people of the state of Michigan versus Nelson Humes. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
And sir, you are Nelson Humes, is that correct?
Yes, sir.
All right, thank you. This is time set for a preliminary examination. Mr. Humes, this is my understanding of what's going on, is that you were assigned conflict counsel, and then the conflict counsel had to move to withdraw because he had a conflict. And so they're still assigning you an attorney. And so we're going to adjourn this until we can get an attorney involved from the public defender who assigns another conflict counsel. And it'll be a good cause adjournment, so you won't waive any rights, all right?
No way.
Yeah. So this is a good cause adjournment just to get a lawyer involved,
Okay.
so you have representation.
Okay.
Is that your understanding, Mrs. L?
That is, Your Honor.
All right. All right. So let's grant the adjournment, and it's going to be adjourned for a good cause. For the public defender to assign a new conflict counsel, which our understanding is they're already working on. Yeah, they're in the middle of assigning a new conflict counsel,
Okay.
according to their office. And we put that email in the file, and we'll reset for a couple of weeks, I would think, at least for subpoenas and such. But we should get a lawyer involved in a couple of weeks. So our next earliest date.
August 28th at 9:30.
Okay, so we'll set it for August 28th at 9:30 for, I'm assuming we're setting it for prelim. But we can,
I think that would be okay, Your
All right.
Honor. If counsel does get assigned, I'll be in touch with them about whether witnesses are necessary.
all right, and then whether they'll get the discovery once they get their appearance in. So Mr. Humes, we've set for August 28th at 9:30. A conflict counsel from the public defender will be down to see you, okay, sir?
At what time?
August
28th?
28th at 9:30.
I'll be back here, or they gonna come?
We'll probably bring you here.
Okay.
Okay, yeah, we'll probably bring you here. So you'll be here regardless.
Is this the prelim or the proper cause?
Prelim.
This is what this.
Yeah, we've set it for prelim. It was set for prelim today, and you should be represented by counsel, know what's all that's going on. So we've just set it for another prelim.
Okay.
Okay. All right. Anything else for the record in 2502289, Mrs. L?
Not for people.
Mr. Humes, I'll see you on August 28th, and your public defender will be down to see you.
I said one more. that's one
Sure.
more. So, I had a proper cause, this prelim or proper cause? Right?
Prelim. This
So
was a
August
prelim.
8th, I mean, last week I had a proper, what come first, proper cause or prelim?
Probable cause conference.
So
Yeah.
this is prelim.
Yeah. So
Okay,
this is.
so
a
I ain't
prelim.
gotta do proper cause no more.
Yeah, what we're doing is just trying to move it along. So we haven't reset it for PCC, just to save us a week.
Okay, now I
'Cause
have to turn
that-
that in.
Yeah,
Okay, thank you.
All
I
right.
haven't had, okay, thank you.
You're welcome.
God bless you.
Actually, good questions.
Yeah.
Because I don't think you want to spend another week incarcerated if that's the case, waiting for the prelim to start.
Right.
All right, Mrs. L, we're all set.
Hey, look, we didn't go into the afternoon. I kept my promise.
You didn't go into the afternoon. Ms. Delvero will be happy.
She actually will be.
Did she have that?
Yeah.
She's got a CSC.
Time.
1:30.
So if you want to see that, come to court with her because it won't be, because she's filed a motion to shut down the courtroom.
That makes sense.
Yeah, because she has an underage witness.
I'll talk to her about that.
Traumatized yesterday.
Yeah, you're the orthodontist.
25-00960. That is People of the State of Michigan versus Titus Owens. Appearances for the record, Ms. Delvero.
Good afternoon, Your Honor. Angela Delvero on behalf of the people.
Mr. Austin.
Thank you, Your Honor, and good afternoon. Jared Austin appearing on behalf of Mr. Owens. He is present with me at council table.
And sir, you are Titus Owens, is that correct?
Yes, Your Honor.
Thank you. This is the time set for preliminary examination today. Ms. Delvero, I have at least one motion for special arrangement and then a intent to use support person. I've read them over. Mr. Austin, do you have any objection to the people's motion for special arrangements?
I do not, Your Honor. I think the law is pretty clear on that. They're entitled to ask for that in this type of case, so I have no basis to formulate an objection.
All right. So at this time, I'm gonna sign the order granting motion for special arrangements. And then you intend to use a support person, is that correct?
That's accurate, and it's Marissa Berry here, the advocate from my office.
All right, any objection to the use of the support person, Mr. Austin?
No, Your Honor, it's, again, that's something I think they can do. It's someone unrelated to the case, which is always my concern in these types of matters, but that's been alleviated because it's a member of the prosecutor's office and not someone who is or would be a potential witness.
All right, perfect. All right, thank you. So with the notice to use the support person, that would, and I think we're just gonna put her on the side.
I moved a chair just so that to move things along, Your Honor.
Perfect.
Yeah.
All right, I will invoke the sequestration order. So counsel knows the case better than I do. So if you see a witness that should not observe another witness testify, other than investigating officer or anyone else that's a part of the case, please bring it to my attention and we'll invoke the order for sequestration. Anything else to come to the court's attention?
No, Your
Ms.
Honor.
Delvero?
No.
Mr. Austin?
No, Your Honor, thank you.
All right. You make Ms. Delvero. I want to make sure that we're not on live stream.